Welcome back. This is the final chapter in the Grayson Bay versus Judge Perkins case. Last time, a jury had already returned guilty findings on most counts, with 2 charges left for trial the following day. That trial never happened. The prosecution chose to dismiss the remaining counts, leaving only sentencing. What followed was not dramatic, but it was instructive. The court addressed the defendant directly and made it clear that courtroom theatrics do not replace legal accountability. Beliefs did not outweigh evidence, and ideology did not override jurisdiction. In the end, the law applied exactly as written. That is how courts work. This is Judge Talks.
Versus Javar Tyrone Grayson, case number SP14643761, SP14640991, SP146390, counts 1, 2, and 3. State your name for the record.
Grayson
Bay. I'm sorry.
Thank you.
State your name for the record.
Grayson Bay.
All right. This is today is the date and time set for a jury trial. Ms. Schneider, can you put your appearance on the record, please?
Your Honor, Alexis Schneider for the people, P80322. For the record, the issuing officer, Officer Ambrose, was present, although I released him.
Mr. Grayson Bay, we didn't conclude some of the. First of all, I want to get the record straight from yesterday. I did mention, and you did cite. Where's Mr. Grayson Bay's file?
If you are paying attention, this is what accountability looks like. The defendant did something rare in these cases. He acknowledged a mistake and corrected course, even if only briefly. That moment mattered more than any argument he made earlier. Courts are not offended by silence or compliance. They are frustrated by noise disguised as legal theory. When you recognize an error and stop digging deeper, you give yourself the only advantage available in a courtroom. That lesson alone was worth the hearing. This is Judge Talks.
Yes. I wanted to clear up something I said on the record as far as the case that you cited out of Alabama. That I was incorrect as far as the facts of that case. Reverend Shuttlesworth was not the case where they were walking down the street and did not obtain the license to assemble. That was a case where he has another reverend organized a sit-in and at a restaurant. The unfortunate part about it is, and that's just how our society is, and it was, and still is for the most part, is that this case had to go all the way to the United States Supreme Court for him to get justice on this case. But again, you're citing cases, sir, that you're not even reading what the case.
There's nothing wrong with citing case law. In fact, judges appreciate it when legal authority is used properly. The problem arises when cases are quoted without context or applied to situations they were never meant to address. In this hearing, the defendant relied on decisions that either had nothing to do with his circumstances or directly contradicted his position. Reading law is not the same as understanding it. Courts do not reward confidence. They reward accuracy. This is Judge Talks.
Fine you. That's something a lawyer would be can be brought up to the grievance commission on and potentially lose their license. All the cases in there, all the cases that you have cited are saying exactly the opposite of what you purport. Have you looked at any of them?
Yes, Your Honor.
And you read them? When did you do that last night?
I've been studying more science. My religion is more science. As you can see, if it looks like a duck, it acts like a duck, it tells you it's a duck, it's pretty much a duck. So I'm more science. So I've been studying for over 10 years.
Labels do not matter here. whether someone adopts a new title, a historical identity, or a self-created legal status. The analysis stays the same. Courts look at conduct, not personal branding. If someone claims exemption from licensing laws, rejects jurisdiction, or denies the authority of the court while still using public systems, the contradiction is obvious. You cannot selectively accept the benefits of law while rejecting its obligations. The court made that line unmistakably clear. This is Judge Talks.
And
But you haven't been studying.
no disrespect to you, Your Honor. I just want to remain mute to the fact and acknowledge that my mother is here, the matriarch of my family, and so I just want to remain mute to this case in this matter. And the floor is yours. This is your courtroom. No disrespect. My mother is here.
No. Ma'am, can you stand up and state your name, please?
My name is Mary Grayson Hall.
Good morning, Ms. Grayson Hall. And it's nothing about, you can see it. I just wanted you to acknowledge, I do acknowledge the fact, and I appreciate the fact that you have support here. The court always recognizes that. That's why I asked you to stand up. But you want to remain mute now, but you didn't remain mute when you filed these pleadings. This is how you speak to the court, exactly the way you did. Now, maybe the form is not exactly the way the court kind of or the rules have applied, but I understand you're in pro per and you might not know all of those rules. But when you start filing these documentations, you're speaking to the court and you're representing that this is the current state of the law as this is the current state of the law, and this stuff applies to your case, and I should be reading this stuff and be able to interpret what you're saying about your case through these cases. And when I read these cases, it says exactly the ones that I've read, and I've seen these cases filed before, it says exactly the opposite of what you're trying to say. Because what I understand you're trying to say is that you're trying to say that you don't need a valid driver's license to drive on the roads, you don't need proper registration on your vehicle, and you don't need proper insurance. And you're even going as far as saying that the police officers, and correct me if I'm wrong, that the police officers do not even have the authority to pull you over. Is that correct?
Again, Your Honor, I remain mute to the situation.
Silence is often the smartest option. Knowing you have the right to remain silent is one thing. Actually exercising that right is another. The more this defendant spoke, the weaker his position became. Arguments that are not legally grounded do not improve with repetition. At sentencing, restraint can do more than any speech. The court does not need explanations when the record already speaks for itself. This is Judge Talks.
And I reply, my mother is here. No due respect to the court. My matriarch is here. And I gave you pretty much documents to read. And I'm standing on those documents, and I'm gonna remain mute. Thank you.
All right, so I've already found you guilty of the count of refusing to exhibit a driver's license, SP 1464091. I'm going to fine you on that case $240. I've already found you responsible on SP 1463901, expired plate. I'm going to fine you $145 on that. And I've already found you responsible on SP 1463903, insurance no proof, and I say guilty on SP 1464091, and that's $240 for the insurance no proof. I'm going to fine you $195 on that. All right. As far as the other counts, I had the note. Well, you told me off the record that you're going to dismiss SP 1464761 and SP 14639-002. Is that correct?
That's correct, Your Honor.
So 145, 195, and $240, sir. When can you pay?
I would probably need, after the holidays, maybe 3 months. I might get something up for you.
Are you working?
I do carpentry.
Yeah, you do carpentry. Are you working?
Yes. Yeah, I have jobs lined up.
Okay, so why do we need so much time?
They lined up. They're not completed. They're just future jobs that I have lined up.
At one point, the discussion shifted toward responsibility beyond the courtroom. The judge addressed work, effort, and personal accountability. This was not punishment. It was context. Courts regularly evaluate whether a defendant is taking steps toward lawful, stable behavior. Employment is not about dignity speeches. It is about demonstrating seriousness. Excuses do not substitute for action, and courts notice the difference immediately. This is Judge Talks.
So presently, you're not working.
Today, I'm not in court.
You got this play on words.
Yeah, I mean, traveling and
Is
driving. Yeah, there be the system. Play on word. I mean, it's the truth, though. I mean, I got to speak the truth to you, right? You respect the truth?
Now, if you,
Okay, I'm not working today. I'm not working.
No. You're not. I'm asking you, why is it taking you 3 months to get up? I don't typically give out 3 months to pay fines, especially when somebody's working, and especially in a career that's a skilled trade, that's a very lucrative career. So I'm trying to give you the time you need, but I need to make a good basis for that.
3 months.
Because you're not giving me a good basis for giving you 3 months, and you're telling me you're a carpenter, and you're telling me you're working. Now, if you're telling me you're a carpenter and I'm not working currently, then that's something that I can go with. But you're telling me I'm just not working today.
Right.
I'm gonna go to work tomorrow.
Very optimistic.
So I'm not giving you 3 months.
I'm very
for that.
optimistic. That's why I say, well, as this present, not, but yeah, tomorrow. I'm very optimistic about work. So yeah, yeah.
So you're not working.
Today, I'm not working. Tomorrow, I have grass work tomorrow to do. There are schedules to do, and I do have a future as a job to have things to be done. But as you saying, as I'm working, I'm telling you the truth, not as now, no. If that clears, if that makes you feel comfortable, no, I'm not working.
I'm trying to ascertain.
No, I'm not working.
What's going on, sir.
I'm not working. At this present moment, I'm not working.
And when you say you're working, you have some aspirations of working,
Yes.
like everybody does. We're
Yes.
looking for, well, not everybody, because not everybody is trying to work.
Right, exactly.
So
Yes.
you're not working now,
Right,
correct?
thank you, Your Honor.
Let me ask you this, ma'am. Is this the kind of, I don't know, I want to make sure that you don't need any mental health services? Do you?
Are you questioning my mental capacity?
I'm asking.
There was a moment where the defendant raised an issue that unintentionally collapsed his entire position. By asking the question he did, he acknowledged the existence of governing law, state authority, and judicial power. That single moment undercut every claim he had made about independence from the system. Courts listen carefully. Sometimes the most revealing statement is the one a defendant does not realize they made. This is Judge Talks.
Because you're giving me these play on words. You're giving me all of this
Speak the
stuff.
truth, Your Honor.
I don't
speak the truth.
I don't feel you're speaking the truth to me.
I'm not working today at this present moment. I'm not working.
And you're not working. You don't have anything set for tomorrow,
No, I don't.
right?
Nope, I don't.
You don't.
I'm
Do you
not
have
even
anything
working.
set for next
No.
week?
No, I'm just anticipating things. You're right. I don't.
Do you understand what I'm saying?
Exactly.
I'm just gonna get you out of here. I'm gonna give you till March the 5th. You can either Zoom in or come in. I'm gonna give you till March the 5th to have the stuff paid off. All right?
Can I get a total of that?
Hearing ended without spectacle, but with clarity. The court exercised lawful authority, imposed sentence, and moved on. Ideological arguments did not survive contact with procedure, evidence, and jurisdiction. That is not personal. That is how the legal system functions every day. Cases like this tend to repeat because beliefs go unchanged even after consequences arrive. For now, this chapter is closed. Thanks for watching Judge Talks.